Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists, and as uncertified podcast hosts, we try to bring our audience of trial and appellate attorneys some legal news and perspectives they can use in their practice. As always, if you find this podcast helpful, please recommend it to a colleague.
Yeah, if you find it unhelpful, listen again at double speed.
Well, Jeff, we've been off for a couple of weeks for the holidays and such. You had an oral argument recently. I had a couple of oral arguments recently, but we're back in the recording studio, such as it is, and we've got a few more cases to talk about. Some of these AI hallucination cases, they just keep coming up. But there's one of these that I thought was interesting enough, had another twist on it that I thought we should mention to our audience. And I kind of wanted to talk a little bit about an amicus brief that my firm filed in the California Supreme Court. Is about the Maniago case that we talked about on this podcast about a year ago, I think, about an interesting issue on appealability. It should be of note to our listeners. And maybe we'll talk a little bit about the Texas redistricting case and the scathing dissent that Judge Smith issued in that recent case. But first, at least at the top of my notes, I thought we'd talk about this AI hallucination case in Shayan versus Shakib. This one and another recent AI hallucination case are both out of the Second District, Division 1. So I don't know how that division drew the short straw to get all of these AI hallucination cases. But in this case, the Court of Appeals sanctioned attorney Fahim Farivar for filing a brief with numerous fabricated quotations falsely attributed to published decisions. The twist in this case is that, unlike a lot of the cases, including the Boy Schiller one, which maybe we'll talk about to see if this, Jeff, if you think this one foreshadows anything that might come out of Boy Schiller. But the different thing in this case is, whereas Boy Schiller and many other attorneys fall on their sword and say, yeah, I made a mistake. We do use AI, but we always check the sites. Just this one happened to go out of the shop without having a second set of eyes on it. This one, the attorney did not fall on his sword. He said, no. When I drafted this thing, I didn't use AI. All of the sites came off of reputable Westlaw research requests. It's just when I handed it off to my staff, it's my staff's fault. I put placeholders in there and told my staff to go find the citations for legal authorities. And then my staff must have gone about and found AI generated support. And that was the origin of the problem. Court didn't like that at all, and didn't like what it perceived as a lack of either a lack of candor or just no one likes blaming the secretary or blaming the staff. The court imposed $7,500 in sanctions. What I thought was a little bit unusual is that the court didn't strike. This is the opening brief, the appellant's opening brief that had the problems in it. The court didn't strike the brief. It actually required and allowed the attorney to file a corrected brief, limited only to fixing the AI hallucinations and miscitations and not making any other substantive changes to the brief, and referred the matter to the state bar. I think the outcome, is going to be doomed anyway. Again, the changes required in the refiled brief are going to be non-substantive, and the sanctions sting and the reference to the state bar is going to sting. I think why the court decided to publish this one is that it went out of its way to note that, look, the hallucinations didn't actually help the appellant. These are not hallucinations that, sometimes you ask AI a question and it'll tell you any old thing to make you happy. It might give you a false case with a proposition that's not supported anywhere else. That didn't seem to be what happened here. Miscitations and hallucinated citations or misquotes didn't really move the ball forward from the standpoint of the appellant. But the court said, nonetheless, we must consider broader concerns about the integrity of the courts and the legal profession. And the court goes on to explain that inaccurate citations in briefing, whether the result of technological hallucinations or a human failure to verify, may be relied on in court decisions, circulated, believed, and become fact and law in some minds. We must all guard against those instances. There is no room in our court system for the submission of fake, hallucinated case citations, facts, or law. So I think the court is putting itself in a guardian of the institution role. This wasn't necessarily just error correction and protecting the parties in this case. It's protecting the judicial system as a whole and making sure that our, California reporters published decisions don't wind up stuffed chock full of fake AI hallucinated quotations and fake cases.
Tim, before the invention of AI, can you recall a case where a lawyer successfully pointed to his staff and said, "Hey, I signed this brief, but my staff did a terrible job. So blame my staff, don't blame me." I don't recall that argument ever working in a published decision.
No, that was in fact one of the earliest bits of mentorship I ever got is do not blame your paralegal or your secretary or your staff. You always take the blame. The buck stops with you as the attorney. You're the one who signs the paper, so you take responsibility for everything in it.
And let me say a second issue comes to mind with these cases. We're seeing a lot of these sanctioned cases involving AI briefs, and they all cite the duty of candor. You can't misrepresent things to the court. It is a continuing duty. The professional rules talk about it being continuing duty. So the moment you discover on your own or otherwise a fabricated brief, you immediately have to draw it to the court's attention, not wait for your opponent. And in this particular case, there was a motion for sanctions and to strike, and there was an opposition filed by the AI brief writer. He opposed sanctions. And in that opposition, he contained inaccurate AI-generated statements of the law. Rule of thumb, if you're going to file an AI-generated brief and you're called on the carpet and you're going to be sanctioned for it, when you're opposing that sanctions request, don't also cite AI-generated cases.
Yeah, do not double down on your AI sins.
Maybe we should put that on our next mug, our next California appellate law podcast mug.
Yeah. Yeah, and we'll put we can put a footnote. This mug not generated with by using AI.
But it is interesting. The lawyer here was allowed to file a corrected brief, and the lawyer's corrected brief characterized whether certain cases were made up or whether they just misquoted cases, etc. And the court further disagreed with how this AI brief writer had characterized his screw up. At this point in time, when you've been caught with a bad brief, whether it's AI generated or first year law student generated, there's a good argument you should back out of the case, I think, and bring in replacement counsel or at the least co-counsel, because you should not be representing yourself in opposing sanctions requests. You're not doing a client any service. I think a lot of these sanctions could have been avoided if new counsel came on board, first counsel fell on his sword, and the issue was nipped in the bud. And we don't see that happening, at least in these published decisions.
No, we haven't, and I know that's one of the issues that's been raised. Or I know you've asked the question in the Boy Schiller Scientology case: should the law firm be recused? Should new counsel have to come in? What do we do with the client and their right to choose counsel? What do we do with having to pay a new firm to come up to speed in the case? That is a thorny issue. So I'm not sure. I mean, I understand your point about, once the attorney's name is in the dock at that point and exposed to sanctions, now he's wearing two different hats. He's representing his client and he's got to save his own skin.
Yeah. 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 I mean, it's like a law school exam question on ethics and professional responsibility in terms of the conflicts that arise after you failed your duty of candor and the continuing duty of candor. It's a huge mess. And by the way, pivoting back to that Scientology mess, since the last time you and I had a podcast, there were two developments. One, argument was scheduled, oral argument on the merits was scheduled and then taken down, canceled. There was a pending motion to file a corrected brief to replace the AI brief with the new brief. That motion was denied. So the court's going to decide the case based on the AI brief. And an amicus party, I can't recall who, filed a request for an amicus brief on the issue of the AI generated brief and whether it should be corrected or not. And that amicus request was denied. And now we're all just waiting to see, is the court going to schedule oral argument on the merits, or is it going to issue some kind of order dealing with the briefing issue? Might this be a case where the AI generated brief lawyer has to get new counsel, or that client has to get new counsel? We're all kind of waiting on pins and needles. Let's see what happens.
Yeah, I'm having a hard time imagining what might happen here, because again, this is the respondent's counsel who committed the AI sin in this case. So it's not going to be as simple, even if it's the appellant's attorney who is doing it, then one straightforward resolution, which might be draconian, is to strike the opening brief, dismiss the appeal, and then let the client go after the attorney for malpractice. That's one available option. You don't have that option. The court doesn't have that option when it's the respondent's attorney who committed the AI sin. If you strike the respondent's brief, then what? I mean, there's no such thing as winning an appeal by default, or for the appellant winning the appeal by default. It just is going to impose more burden on the court staff to do all that research. And why wouldn't the staff, even if it's a stricken brief, you might reach for it anyway? It's still, even if some of the, now you know what citations are AI generated and not to be relied on because you have that that proposed amended respondent's brief in the system, even though it's technically stricken. Why wouldn't, if you're the research attorney, you tell me you wouldn't reach for that as a crib sheet to kind of help direct your research and analysis?
Right. Right. Yeah. Who knows?
Yeah. So the fact that they have taken the oral argument off calendar, they have, and yet have denied the motion for leave to file a corrected brief. But remind me, Jeff, they have not stricken the respondent's brief?
Correct. Correct.
Well, I don't know. I guess maybe if I had to hazard a guess, maybe they just leave that brief on the record. I mean, it's not publicly available other than, through like a Public Records Act request, you can get it, but it's not available for downloading on the docket, right? So
I
it's
might
not.
be mistaken, but I think there is a journalist who runs a Substack called Underground Bunker who covers Scientology stories. He's got a lot of the briefing verbatim, not the PDF, but the text of the briefing. If you want to follow him, you get a
Yeah.
lot of the inside scoop.
I guess.
The other thing
Yeah.
that comes to mind is this is Division 5 of the Second District that's dealing with this Bixler case, the Scientology case. Some of these other sanctions cases we've talked about are other divisions. And, I guess each division of the Second District can decide how they're going to deal with these issues separately.
Here's one other juxtaposition between this Cheyenne case and the Boy Schiller Scientology case. So the appellant's attorney in Cheyenne was not penitent, did not own the problem, and got dinged $7,500 and reported to the state bar. The Boy Schiller attorneys did fall on their sword. They were penitent. But as soon as they were alerted to the fact that there were AI hallucinated and incorrect citations in their brief, they sprung into action and did everything they could have done. Are they going to get sanctioned the same as this attorney in Cheyenne, who was not penitent and didn't do any of the things he was supposed to do?
And by the way, as far as we know, they didn't use AI to generate an opposition or the briefing on the issue of the replacement brief. Yeah, I don't know how much penitence comes into play, but I don't know. It'll be interesting to see what happens.
Yeah. Okay. One other thought I wanted to share for you and our audience. I had a thought on what constitutes an unreasonable violation of the rule. So there's the ethical rule that we attorneys have is not to misstate legal authorities to the court, and it's not just to misstate; it's to engage in an unreasonable act of misstating the law. And it occurred to me that the courts have been swift and in many cases quite severe in enforcing against unreasonable violations of the rule when they are generated through AI. But AI is new, but attorneys stating balderdash legal propositions in briefs is not new. That's a venerable old tradition. And yet I don't know of of very many instances where attorneys just kind of running off the cuff and stating what they think the law is in their briefs and thereby often misstating what the law is. I don't see them very often getting sanctioned as engaging in an unreasonable violation of the rule against misstating the law. So it seems like misstating the law, if you're just reciting it from memory or you're kind of characterizing it in a sloppy fashion, that doesn't count as an unreasonable violation. But if you follow it by a citation to an authority that doesn't match or is a hallucinated case, then you're in trouble. That's maybe that gets back to the gatekeeping function that the court talked about, that inaccurate citations in briefing are maybe a different problem than an attorney stating legal balderdash in a brief. Because if it's followed by a citation, that heightens the risk that it's going to get picked up and dropped into a published opinion somewhere.
There's no safe harbor balderdash rule for the rules of professional conduct. There's no duty of candor exception for balderdash. I think, in oral arguments, sometimes you and I would get asked questions by the justices that we're not prepared for. We might say, "Oh, I think The Cole case says blah, 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 and you'll never in 100 years be sanctioned for that. But if you're winging it in a brief, misstating the law, that's a violation of the duty of candor. And even if you didn't know it was wrong initially when your opponent points it out, you're now having a continuing duty to correct it in terms of your duty of candor. So I don't know.
I
I'm with
agree with
you.
you. I agree with you. I just don't think that it's enforced most of the time. I think it's
Yeah.
largely just accepted as, well, gosh, that's just what happens all the time. Lawyers just put things in brief, especially in trial courts where things are busy. You don't always have the time to research all of your legal propositions.
I will say fake cases or uses of AI where you're including the chat GPT prompt in your brief really makes it easy to enforce the rule.
Yeah. Yeah. It's especially easier when you are purporting to quote from a case and that quote does not actually appear in the case. Here's actually a good example. I'll just mention this because I had flagged this when I was reading the case, the Shayan versus Shakib case. The
Mhm.
example that the opinion flags is that the appellant cited or quoted this purported quote. Now, this is the fake quote. It's about the sham pleading doctrine. And the quote that purports to come from the Berman versus Bromberg case, which is a real case, but it's a fake quote. And the fake quote is, the sham pleading doctrine is not intended to prevent honest clarifications or refinements based on subsequent discovery or reflection, end quote. Now, Jeff, I don't know. You know what the sham pleading doctrine is. I mean, you can make certain kinds of changes, but this isn't quite it. Now, the language that actually appears in the case is quite longer, but the nub of it that gets closest to what that fake quote says is this. It is not a rule, however, talking about the sham pleading doctrine, it's not a rule which is intended to prevent honest complainants from correcting erroneous allegations of generic terms which may have legal implications, but which are also loosely used by laymen or to prevent the correction of ambiguous statements of fact, end quote. So those two things are kind of similar, but they have important differences. And here's my proposition. The reason I went through that exercise is I think if the attorney had taken that same sentence but not quoted it as being an actual quote from Berman, I think a careful reader would have looked at that, gone back to the Berman case, and concluded, I don't think you intentionally mischaracterized it, but you overstated it. So I don't think that would be an unreasonable misstatement. I don't think that would be an ethical violation. But putting it in quotations is what goes over the line and commits the sin.
Well, let me go a step further. You get your opponent or the court or the research attorney's attention by having fake cases. If there wasn't a fake case issue, if all you did was quote things inaccurately, I don't know if this is a sanctions case. Maybe it's a footnote in an admonishment case. It's really the fake cases that are getting everybody riled up. And those lawyers who double down with throwing their staff under the bus or doing anything other than falling on their own sword.
Yeah. Well, let's go on to one other AI hallucination case. It's a published opinion, I think, but the AI hallucination discussion is not published. And that's the part we're going to talk about. This is same district and division, second district, first division, court of appeal in County of Los Angeles versus Niblet. There, the attorney used AI to prepare the opening brief in the appeal, citing non-existent cases and misrepresenting holdings of real ones. The interesting one, misrepresentation, is this is a DVRO case, and it misstated the Supreme Court Rahimi case, which is quite a famous case, talked about quite a lot, and misstated it as saying that as concluding that the Supreme Court overruled and invalidated a Texas law, which is the opposite of what it did. It reversed the Fifth Circuit, which had done so, and instead upheld the Texas law. And so that was an important AI hallucination or misstatement of a real case in that case. But again, of note in this case, a counsel failed to correct the miscitation of the cases appearing in the opening brief, despite the fact that the county had pointed out those errors. So the appellant attorney's behavior is troubling and presents potential ethical issues that we cannot ignore. Court also flag this sentence. that the court said it is also presumptuous to assume that he, the attorney, would not be quote unquote caught. Attorney Lucas apparently believes that we do not read cases cited in briefs. And more disturbing is his apparent disregard of his duties as an officer of the court. Our legal system, this again echoes the gatekeeping function recited in the Shayan case. Our legal system depends on the integrity of counsel and the bench. Citing non-existent authority or misciting holdings of cases tarnishes the integrity of the process, end quote. But again, this was another case where it didn't seem like the citations or misstatements really came to anything, but the court is still, making an example of the fact and upholding its gatekeeping function.
Yeah, this one's not published because I don't think it really plowed any kind of new ground in terms of the holding. I will say, I did take a look at the online docket, and the court did end up right before Thanksgiving filing an order that this attorney pay $5,000 in sanctions, and that he be reported to the state bar.
Yeah, that's the sting is getting the sanction and getting reported to the state bar. Of course, then again, I don't know what's if those things. If I could have the choice of writing a check but not having my name blazoned on an opinion as another AI cautionary tale, I think I would write the check.
Yeah.
Okay, let's move on from the AI hallucinated cases, and I wanted to brag a little bit about an amicus brief that my firm filed a couple weeks ago in the Maniago case. We had talked about this on the podcast about a year ago or so when it came out, Jeff. This was a case where it involves the interesting issue of appellate procedure, whether a voluntary dismissal is an appealable order. And what happened in this case is the plaintiffs had their main legal theory gutted. This was looks like a medical malpractice and negligence tort case involving being exposed to HIV blood during a visit to a medical facility. But their main cause of action, or their main theory, was gutted in a demur, and there was not enough left of the case to justify, burning all of the fuel in litigation and going through the trial when it wasn't going to involve their flagship theory. So they voluntarily dismissed the rest of their case with prejudice to expedite the appeal. But the 4th District Division 1 said, no dice, a voluntary dismissal is not an appealable order because it's a ministerial act entered by a clerk, and ministerial acts are not appealable. And the Supreme Court of California has taken that up on review, and our firm decided to file an amicus brief in support of the appellants in this one, and in favor of the position that a voluntary dismissal is an appealable order. We take the position that it ends the case. It's full and final, no less than a judge-signed order. And that's really the hallmark for appealability, is that it brings the case to an end. Otherwise, you could have many cases sitting around on the docket that whose appealability could be revived if a judge just decides that, well, this was voluntarily dismissed years ago. There was never a judicial act that ended it, but if I just go ahead and enter and sign a dismissal, suddenly it is now an appealable order, and the judge could manufacture appellate jurisdiction. That seems like an interesting wrinkle to me. And besides 581D, Code of Civil Procedure Section 581D, which does require that judge-ordered dismissals be done in a signed document, that was relied on by the venerable California Academy of Appellate Lawyers, who filed an amicus brief in support of the respondent in defending the 4th District Division 1 decision and holding that voluntary dismissals are not appealable because they are ministerial acts, and also relied on 581D, which requires that dismissals ordered by a judge be in a signed document. And there was no signed document here, therefore no appealability. The reason I think that doesn't track, if I may respectfully dissent from the Academy, I don't see 581D being an appealability statute, or as expressing any legislative intent or in order to address an issue of appealability. I think that was only to make sure that when a judge orders a case dismissed, for clarification and transparency purposes, it needs to be done in a signed order and be entered. But it doesn't mean that the legislature was drawing a distinction in terms of finality and incorporation of all prior orders between judge-signed dismissals and voluntary dismissals or otherwise clerk-signed dismissals.
Tim, I think it's a good thing you're an appellate lawyer, because only someone like you could find that issue scintillating.
All right. Well, I guess buyer beware when you tune into the California Appellate Law podcast. Sometimes we do make good on appellate law.
Yeah. Before we sign off, let me share one quick tidbit. I came across something new in my practice. First time in 30 years I've seen one of these. Tim, you've seen an appellate brief right before the court accepts it for filing with a little stamp on the top that says received. You've seen those briefs, right? Where it says received by the Court of Appeal. And you've gotten that good feeling when you got a brief from the Court of Appeal that says filed, a relief, right? And you've also gotten the dread when a certain clerk in Orange County, who will go nameless, rejects your brief and you get the true filing rejection notice. You've seen that, right?
Yes.
Have you ever seen, this is a first for me, a brief that has the filed stamp on it and then in big giant red letters, canceled? Have you ever seen a canceled brief?
Whoa, it's what the filing, the act of filing was canceled?
Yeah. And to signify that, they return the brief to you with big red letters saying canceled.
I have never seen that. I assume that has to happen fairly contemporaneous with the filing itself, like same day or next day.
Yeah. So I have a case. It's a little bit complicated, but to make it more simple, the appellant, who's not me, filed his opening brief. I filed my response. An appellant got sick or busy or something, never bothered to file the appellant's reply brief, and the court deemed the case fully briefed. He tried to file a application for extension of time like 3 months later. The court said, no, briefing's complete. He then filed a reply brief in a related case and tried to simultaneously file it in my case. And the court initially accepted it for filing. And I was surprised. I was getting ready to file a motion to strike. And the court, a couple hours later, returned a document saying canceled in bright red letters. The brief he had filed, he kind of tried to sneak it in there, was canceled. A first for me.
Well, good for you to, yeah. So it was, filed late and initially you thought he got it snuck in.
Good lesson that the clerks are paying attention. Even if they don't catch it the first time, they will catch it the second time.
Yeah. Yeah. Have you noticed, just as a matter of a custom, it seems like if you've got a brief with either a soft deadline or a hard deadline, in our shop we call the soft deadline the deadline for an opening brief or a respondent's brief before a Rule 8.220 notice of default has been issued. So we call that the soft deadline. And whether it's a soft or a hard deadline, the clerk will not issue a notice of default, or if it's a hard deadline, the clerk will not dismiss your appeal for failure to file a brief as long as you've got an application for a briefing extension pending.
Yeah, I think that's true. Yeah.
Okay. I'm not sure if I have the confidence yet to elevate that to like an absolute universal rule in California appellate courts, but that's been my experience as well.
Yeah. Yeah.
Okay. Well, Jeff, did you want to talk briefly about the Texas redistricting case and the rather heated dissent by Judge Smith in that split decision that came down just in the past week?
Well, sure. Yeah. I saw this brief come down in the news, or the injunction come down in the news. The thing that struck my eye, because I'm an appellate lawyer and find some of these nerdy issues interesting, is that at the trial level, this court was heard by 3 judges, big 2 district level judges and an appellate justice. And in the first instance, decided by 3 judges. There's no intermediate review of this injunction that was issued by these 3. Instead, the next option or the next stop is a discretionary review in the Supreme Court. So I found that structure kind of interesting, but it is an election law case, so maybe some urgency is required to skip intermediate review. So that was one thing. And the second thing is, there was a dissenting opinion where this judge, who did not agree that the injunction should issue on the redistricting in Texas, boy, did he call out the author of the majority opinion issuing this injunction, take some personal pot shots, and it was one of the more emotional dissents I've ever read.
Yeah, I read the I've listened to some of the commentary on it, and I have not read the dissent itself, but yeah, I do get the impression that it was quite heated. I'm not sure until I dig into the actual opinions whether I quite understand why it's so heated. Other than elections are heated things, and so election decisions are going to be heated things. It reminds me of what was the name of the case? The Second Amendment case that we talked about a couple of years ago, where there was some interesting maneuvering by Judge Van Dyke, writing the majority opinion and then also concurring to his own majority opinion, writing the.
Yeah, but even though I didn't agree with what he did there, he didn't. I mean, it was cute, it was interesting, but he didn't personally attack the justices. He attacked arguments, not judges. That's the difference here.
Maybe there's some line drawing of what constitutes a personal attack. My recollection of Judge Van Dyke's opinion in that case was that he didn't call anyone out by name, but he was accusing generally his colleagues in the Ninth Circuit of, trying to have it both ways on when it comes to Second Amendment jurisprudence, and kind of quietly either disregarding some high court precedent. And so it was now maybe that's when within the lines, but I guess in my mind it just comes within the same piece of no pulling punches anymore with these appellate judges when it comes to high leverage issues like elections, like First Amendment issues, Second Amendment issues, some of these high profile culture war issues. There's no punches to be pulled. We're going to go right for the jugular. We're going to call things as we see it, so to speak.
Well, let me read from the dissent in this Texas redistricting case. I know we're running long here, but let me just read a little bit. In the dissent, he says, this is how he starts. The main winners from Judge Brown's opinion, Judge Brown wrote the majority on the injunction. The main winners from Judge Brown's opinion are George Soros and Gavin Newsom. The obvious losers are the people of Texas and the rule of law. I dissent. And then he goes on to say, in 37 years as a federal judge, I've served on hundreds of three-judge panels. This is the most blatant exercise of judicial activism that I have ever witnessed. That's boy, he's emotionally invested in this case.
Yeah. Well, again, it's a piece of these high leverage disputes when they don't go the way that you think they ought to go, and they're going to have impact on significant issues of national import. In this case, an election that could turn the tide of the next term in Congress.
Tim, I've never worn the black robe, so maybe I'll never know. But isn't it moments like this when the stakes are so high and so many eyes are on the issue and so much is riding, when you really need to attack arguments and principles and not people? Because everybody's taken a lesson from that about, lawyers look at how judges write and sometimes emulate judges, for better or worse. I don't know. I expect more.
Yeah, I may agree with you. Without having read the opinion, I don't want to say more, but I agree with that sentiment that when you do wear the black robe, you do have a duty to protect the institution, and you don't want to start calling it out as personal or partisan unless you're truly at the end of your rope.
Yeah.
Well, okay, we better break it there. So that'll do it for us this week. If you have any suggestions for topics or guests to bring on the podcast, please let us know at info@calpodcast.com. As always, if you need tips on how to lay the groundwork for an appeal when preparing for trial, tune us in next time.